Hello dear students, today we are going to discuss doctrine of locus standi. Before going through this lecture, first let's have a look on its objectives. Number 1. To develop the concept of locus standi. Number 2. To trace out the rationale behind evolution of doctrine of locus standi. Number 3. To develop understanding of the right of constitutional remedies. Meaning of locus standi. Locus standi is a Latin term which means legal standing before a court. In law, standing or locus standi is the term for the ability of a party to demonstrate to the court sufficient connection to and harm from the law or action challenged to support that party's participation in the case. Standing exists from one of the three causes. Number 1. The party is directly subject to an adverse effect by the statute or action in question, and the harm suffered will continue unless the court grants relief in the form of damage or a finding that the law either does not apply to the party or that the law is void or can be nullified. This is called the something to lose doctrine, in which the party has standing because they directly will be harmed by the conditions for which they are asked the court for relief. Number 2. The party is not directly harmed by the conditions by which they are petitioning the court for relief, but asks for it because the harm involved has some reasonable relation to their situation, and the continued existence of the harm may affect others who might not be able to ask a court for relief. Number 3. The party is granted automatic standing by act of law. Under some environmental laws in the United States, a party may sue someone causing pollution to certain waterways without a federal permit, even if the party suing is not harmed by the pollution being generated. The law allows them to receive attorney's fees if they substantially prevail in the action. In some US states, a person who believes a book, film, or other work of art is obscene may sue in their own name to have the work banned directly without having to ask a district attorney to do so. Australian jurist Leslie Steen defines locus standi as the existence of a right of an individual or group of individuals to have a court enter upon an adjudication of an issue before that court by proceeding instigated by the individual or group. In the United States, the current doctrine is that a person cannot bring a suit challenging the constitutionality of a law unless the plaintiff can demonstrate that he or she is or will imminently be harmed by the law. Otherwise, the court will rule that the plaintiff lacks standing to bring the suit and will dismiss the case without considering the merits of the claim of unconstitutionality. In Canadian administrative law, whether an individual has standing to bring an application for judicial review or an appeal from the decision of a tribunal is governed by the language of the particular statute under which the application or the appeal is brought. In British administrative law, the applicant needs to have a sufficient interest in the matter to which the application relates. This sufficient interest requirement has been construed liberally by the courts. As Lord Diplock put it, it would be a grave danger to escape lacuna in our system of public law if a pressure group or even a single public spirited taxpayer were prevented by outdated technical rules of locus standi from bringing the matter to the attention of the court to vindicate the rule of law and get the unlawful conduct stopped. The Supreme Court has liberalized the law pertaining to locus standi to broaden its implications. An aggrieved person may be granted a writ of locus standi even if his legal right has not been specifically violated. Development of the rule of locus standi. Law, it is said, is dynamic. Naturally, our perception of locus standi also has been undergoing transformation. The traditional conception in regard to locus standi is that judicial redress is available to a person who has suffered a legal injury by reason of violation of his legal right or legally protected interest by the impugned action of the state or a public authority, or who is likely to suffer a legal injury by such reason. The courts have during recent years evolved a number of exceptions to this rule. Courts have now acknowledged that where there has been violation of constitutional or legal rights of a person who, by reason of their socially or economically disadvantaged position, are unable to approach the court for judicial redress, a member of the public could move the court for enforcement of such rights of such persons. Members of the public are enabled in appropriate cases to come forward to protect the rights of a person or persons belonging to a determinate class who by reason of poverty, helplessness or disability or socially or economically disadvantaged position are unable to approach the court for relief. This principle has been extended to cases where no specific legal injury is caused to a person or to a determinate class or group of persons by the act of omission of state or public authority, and injury is caused only to public interest. Where there is a public wrong or public injury by an act or omission by the state or a public authority which is contrary to the Constitution or to any law, any member of the public having sufficient interest can maintain an action to or redress such public wrong or public injury. Courts have begun to recognize that they exist not merely to vindicate individual rights but also to vindicate public rights, and therefore permit members of the public to agitate such rights. Any member of the public having sufficient interest can maintain an action for judicial redress of public injury arising from breach of public duty or violation of some provisions of the Constitution or the law, and seek enforcement of such public duty and observance of such constitutional or legal provision. Of course, it must be ensured that the person who comes forward is acting bona fide and not for personal gain or private profit or out of political motivation or other oblique consideration. Rule of locus standi and Constitution of India. According to the jurisprudence of Article 32 of the Constitution of India, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Ordinarily, only the aggrieved party has the right to seek redress under Article 32. In 1981, Justice P. N. Bhagwati in S. P. Gupta v. Union of India articulated the concept of PIL as follows: where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision, or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons by reason of poverty, helplessness or disability or socially or economically disadvantaged position unable to approach the court for relief, any member of public can maintain an application for an appropriate direction, order or writ in the High Court under Article 226, and in case any breach of fundamental rights of such person of determinate class of persons in this court under Article 32, seeking judicial redress for the legal wrong or legal injury caused to such person or determinate class of persons. The rule of locus standi have been relaxed, and a person acting bona fide and having sufficient interest in the proceeding of public interest litigation will alone have a locus standi and can approach the court to wipe out violation of fundamental rights and genuine infraction of statutory provisions, but not for personal gain or private profit or political motive or any oblique consideration. Writ jurisdiction under the Constitution of India. The writ jurisdiction is provided under Articles 32 and 226 of the Constitution of India 1950. The writ jurisdiction of Supreme Court can be invoked under Article 32 of the Constitution for the violation of fundamental rights guaranteed under Part 3 of the Constitution. Any provision in any constitution for fundamental rights is meaningless unless there are adequate safeguards to ensure enforcement of such provisions. Indian Constitution, like most of Western Constitution, lays down certain provisions to ensure the enforcement of fundamental rights. These are as under: Number 1. The fundamental rights provided in the Indian Constitution are guaranteed against any executive and legislative actions. Any executive or legislative action which infringes upon the fundamental rights of any person or any group of persons can be declared as void by the courts under Article 13 of the Constitution. Number 2. In addition, the judiciary has the power to issue the prerogative writs. These are the extraordinary remedies provided to the citizen to get their rights enforced against any authority in the state. These writs are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Both high courts as well as the Supreme Court may issue the writs. Number 3. The fundamental rights provided to the citizens by the Constitution cannot be suspended by the state as laid down in Article 359 of the Constitution. A fundamental right may also be enforced by way of normal legal procedures, including a declaratory suit or by way of defense to legal proceedings. However, Article 32 is referred to as the constitutional remedy for enforcement of fundamental rights. This provision itself has been included in the fundamental rights and hence it cannot be denied to any person. Dr. B.R. Ambedkar described Article 32 as the most important one, without which the Constitution would be reduced to nullity. It is also referred to as the heart and soul of the Constitution. By including Article 32 in the fundamental rights, the Supreme Court has been made the protector and guarantor of these rights. Under Article 32, the Supreme Court may issue a writ against any person or government within the territory of India. Where the infringement of a fundamental right has been established, the Supreme Court cannot refuse relief on the ground that the aggrieved person may have remedy before some other court or under the ordinary law. A public interest litigation can be filed before the Supreme Court under Article 32 of the Constitution or before the High Court of a state under Article 226 of the Constitution under their respective writ jurisdictions. There are mainly 5 types of writs. Number 1, writ of habeas corpus. Number 2, writ of mandamus. Number 3, writ of quo warranto. Number 4, writ of prohibition. And number 5, writ of certiorari. Locus standi in public interest litigation. The expression litigation means a legal action including all proceedings therein initiated in a court of law with the purpose of enforcing a right or seeking a remedy. Therefore, lexically, the expression bill means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of community have pecuniary interest or some interest by which their legal rights or liabilities are affected. The concept of bill, which has been and is being fostered by judicial activism, has become an increasingly important one, setting up valuable and respectable records, especially in the arena of constitutional and legal treatment for the unrepresented and underrepresented. The Supreme Court has widely enlarged the scope of bill by relaxing and liberalizing the rule of standing by treating letters or petitions sent by any person or association complaining violation of any fundamental rights and also entertaining writ petitions filed under Article 32 by public spirited and policy-oriented activists, persons or journalists or of any organization rejecting serious challenges made with regard to the maintainability of such petitions and rendered many virtuous pronouncements and issued manifold directions to the central and the state governments, all local and other authorities within the territory of India or under the control of the Government of India for the betterment of the public at large in many fields in conformity with constitutional prescriptions of what constitutes the good life in a socially just democracy. Subjects of public interest litigation. Public interest litigation is meant for enforcement of fundamental and other legal rights of the public who are poor, weak, ignorant of legal redress system or otherwise in a disadvantageous position due to their social and economic background. Such litigation can be initiated only for redressal of a public injury, enforcement of a public duty, or vindicating interest of public nature. It is necessary that the petition is not filed for personal gain or private motive or for other extraneous consideration and is filed bona fide in public interest. There are three basic requirements to file the public interest litigation. They are number 1, personal injury, number 2, causation, and number 3, redressability. Expansion of locus standi. One of the most important issues confronting the public interest litigation was the problem of locus standi, which stood in the way of weaker sections of the society. Who should have standing or legal capacity to challenge an administrative act or omission or commission which was productive of public mischief or public inquiry without affecting any private right, law litigation which was of ancient vintage and insisted on direct injury to the aggrieved person who alone could bring an action. It was designed to protect the individual against specific injury caused to him by the state. The state was taught to be the sole guardian of public interest and individual has no role to play in overseeing the administration. Individual as such exercise no general control over the administration to check its illegal actions or abuse of power by activizing the judicial process against them. Restrictive rule. Under the restrictive rule of locus standi, only a person aggrieved could go to the court for relief. Other members of the public has no access to court unless they also suffered an additional or special injury. Flexibility introduced a narrow concept. In course of time, courts had shown some flexibility in their narrow approach to locus standi by broadly interpreting words aggrieved person. But they did so without any conscious desire to liberalize the rules. Even before the advent of public interest litigation, the courts had evolved some exception to strict and traditional requirements of standing. A few exceptions to traditional view of locus standi were accepted in different cases by different jurists. Community orientation of locus standi. Public interest litigation took a new dimension in 1980 when the Supreme Court came forward to protect public interest against common injury, danger, annoyance or obstruction to people in general by local authority, public undertaking or municipal corporations. In Ratlam Municipal Council versus Vardi Chand, the plea of municipality of lack of funds to carry out the amenities was rejected as an invalid defense and suggested several schemes to bring reliefs to the residents of the locality. Besides broadening the locus standi, the affirmative action invoked by the court in this case opened up infinite possibilities for creative approaches in judicial action in the service of large group of people. Locus standi, in its long march from ancient tradition to the modern trend, has covered many milestones from the requirement of injury to legal rights, the concept of individual interest, then to special interest, again to class interest, and now to sufficient interest. In Sunil Batra versus Delhi administration, the locus standi of a fellow prisoner was recognized and the Supreme Court accepted the habeas corpus of a fellow prisoner complaining a brutal assault by the head warden on another prisoner. The court broadened the scope of habeas corpus by making it available to a prisoner not only for seeking his liberty but also for the enforcement of rights to which he was lawfully entitled even during his confinement. Complete liberalization of locus standi. Clearing all impediments, abstracting development of public interest litigation, a comprehensive exposition was given to the concept of pill in the judgment of judges transfer case. In S.P. Gupta versus Union of India, the judges have given ultimate farewell to the concept of locus standi. A way for free flow of public interest litigation was proved. The scope of pill was thus enlarged to a great extent by Justice Bhagwati, who proved to be the architect of pill jurisprudence in India. In Fertilizer Corporation Kamgar Union versus Union of India, Justice P.N. Bhagwati stated as under: in simple terms, locus standi must be liberalized to meet the challenge of the time. Ubi us ebi remedium must be enlarged to embrace all interests of public-minded citizens or organizations with serious concerns for the conservation of public resource and the direction and correction of public power so as to promote justice in its trinity facet. Restrictive rules of standing are antithesis to a healthy system of administrative law. Public interest litigation is a part of the process of participation, justice, and standing in civil litigation of that pattern must have liberal reception at the judicial doorsteps. In another matter, a journalist, Miss Sheila Bas, took up the plight of women prisoners who were confined in the police jails in the city of Bombay. She asserted that they were victims of custodial violence. The court took cognizance of the matter and directions were issued to the Director of College of Social Work, Bombay. He was ordered to visit the Bombay Central Jail and conduct interviews of various women prisoners in order to ascertain whether they had been subject to torture or ill treatment. He was asked to submit a report to the court in this regard. Based on his findings, the court issued directions such as the detention of female prisoners only in designated female lockups guarded by female constables and that accused females could be interrogated only in the presence of a female police official. In Delhi Domestic Working Women's Forum versus Union of India and others, the court expressed serious concern about the violence against women. The court gave significant directions and observed that compensation for victims shall be awarded by the court on conviction of the offender and by the Criminal Injuries Compensation Board whether or not a conviction has taken place. The board will take into account pain, suffering and shock as well as loss of earning due to pregnancy and the expenses of childbirth if this occurred as a result of the rape. In D.K. Basu versus State of West Bengal, the court observed that the custodial death is perhaps one of the worst crimes in a civilized society governed by the rule of law. The rights inherited in Article 21 and 22 Clause 1 of the Constitution require to be zealously and scrupulously protected. The expression life or personal liberty in Article 21 includes the right to live with human dignity and thus it would also include within itself a guarantee against torture and assault by the state or its functionaries. The precious right guaranteed by Article 21 cannot be denied to convicts under trials, detainees and other prisoners in custody except according to the procedure established by law by placing such reasonable restrictions as are permitted by law. The court gave very significant directions which are mandatory for all concerned to follow. With this, I conclude today's lecture, Doctrine of Locus Standi. Hope you have enjoyed today's session. For now, it's time to say goodbye. Stay blessed.